And tonight, the Attorney General of the United States is under subpoena. The Washington Post reports the House Oversight Committee has subpoenaed Attorney General Pam Bondi as part of its probe of the Justice Department's investigation into deceased sex offender Jeffrey Epstein, ordering her to testify before the panel on April 14th. If Bondi honors the subpoena, she would face committee members' questions in a closed-door session that could turn contentious, given the volatile nature of the Epstein case and Bondi's demonstrated willingness to engage lawmakers in verbal combat. A Justice Department official, however, quickly dismissed the subpoena as pointless, declining to say whether the Attorney General would comply. In his letter today to Pamela Bondi, Republican House Oversight Committee Chairman James Comer wrote, "The committee has questions regarding the Department of Justice's handling of the investigation into Jeffrey Epstein and his associates and its compliance with the Epstein Files Transparency Act. As Attorney General, you are directly responsible for overseeing the department's collection, review, and determinations regarding the release of files pursuant to the Epstein Files Transparency Act, and the committee therefore believes that you possess valuable insight into these efforts." Joining us now is Democratic Congressman Ro Khanna of California. He's a member of the House Oversight Committee. Congressman Khanna, it is your law, the bill that you got passed, the Epstein Files Transparency Act, that the Attorney General seems to have violated repeatedly. That presumably would be the center of your questioning if she shows up for this this questioning.
Absolutely. And Lawrence, the important thing here is it's not Thomas Massie and I writing to Pam Bondi or subpoenaing Pam Bondi. It is Jim Comer, the Republican chair, issuing this subpoena.
In our last report, we examined the testimony of Attorney General Pam Bondi before the House Judiciary Committee. We documented her claim that Ghislaine Maxwell was transferred to a same-level facility. We showed that claim to be false. We documented her refusal to identify who authorized the transfer. We documented her use of whataboutism to avoid direct questions about the Department of Justice's handling of the Epstein case. We noted, on the record, that her testimony contained specific factual statements that are contradicted by verifiable prison classification records. Tonight, the institutional process has responded. The Attorney General of the United States is now under subpoena. This development requires precise analysis, because a subpoena is not a political attack. It is not a partisan maneuver. It is a formal legal instrument issued under the authority of the United States Congress. It compels testimony. It compels document production. And non-compliance carries legal consequences that the Department of Justice, the very department Bondi leads, is normally responsible for enforcing. Let us examine what just happened and what it means. The subpoena was issued by the House Oversight Committee. The chairman of that committee is James Comer. James Comer is a Republican. This is not a Democratic subpoena. This is not opposition research dressed in legal clothing. This is the Republican chairman of a Republican-controlled committee issuing a formal legal demand to a Republican Attorney General appointed by a Republican president, because members of his own party have lost confidence in her willingness to comply with the law. That sentence needs to be read again. Members of her own party lost confidence in her willingness to comply with the law. The letter from Chairman Comer states the committee has questions regarding the Department of Justice's handling of the investigation into Jeffrey Epstein and his associates. It cites the Epstein Files Transparency Act, a law passed by Congress that the Attorney General is directly responsible for implementing. The letter states she possesses valuable insight into these efforts and must appear to answer for them. The Epstein Files Transparency Act was passed with bipartisan support. Its purpose was simple. The American people were promised transparency on the Epstein files. The law created a legal obligation for the Department of Justice to collect, review, and release those files within a defined time frame. That deadline passed. The files were not fully released. Documents were withheld. Identities were concealed. And the Attorney General, when asked about this in open testimony, could not, or would not, explain why. Now she has been subpoenaed to explain it under oath. There is one additional fact that defines this moment. The same day the subpoena was issued. The same day, the Department of Justice informed the committee that Bondi and Todd Blanche would appear for a closed door briefing the following evening. The subpoena went out in the morning. By afternoon, the Attorney General, who had refused to answer questions for months, suddenly found time in her schedule. We are going to examine exactly what that tells us. But first, the second clip.
So was that arranged just because this subpoena was issued?
Certainly seems coincidental. The day the subpoena goes out, we are informed today that Pam Bondi wants to come tomorrow to meet with us. I mean, Thomas Massey and I have been requesting a meeting for months with her and Blanche to be able to protect the survivors. The committee has been requesting a meeting for months. Suddenly, now that she has a threat of a subpoena, she's coming to meet us because she knows that the theatrics won't work. Closed doors under deposition. The reality is that she would be asked questions under oath by lawyers, that she would be subject to the penalty of perjury, and that will haunt her long after she's Attorney General. So my sense is she's coming tomorrow to try to diffuse the subpoena, but I doubt that she's going to be able to convince Republicans to have her not comply.
So this is breaking news about her reaction to this, to get a subpoena and then say, oh, let me talk. I mean, that is really the equivalent of, getting indicted or something and trying to plea bargain right away. So is the full committee invited into this discussion with her tomorrow?
That's my understanding. And yes, it is quite a breaking news because I just learned about this a few hours ago. My understanding is she's coming closed doors behind the full committee with Blanche, and she wants to brief our committee. We've been asking for this briefing for months, and she has not been willing to give it. And my hope is that Comer is going to pursue her subpoena with the same relentlessness that he pursued the Clintons. The reality is she needs to answer basic questions under oath, questions such as why were 3 of the witness interviews about the woman who accused President Trump of rape when she was 13, why were they withheld? Why have so many of the documents been scrubbed back in March and concealed the identity of rich and powerful men whose survivors have named in the 302 forms? Why did you refuse to meet with the survivors or their lawyers when you were releasing these files? Why did you refuse to take a meeting to protect their identity? There are a lot of questions that we have of her and that she's going to have to answer under oath. And my sense is she doesn't want to do that.
Let us now perform a forensic examination of what Congressman Khanna just described. He said something that requires careful attention. He said that in a closed-door session, under deposition, the theatrics will not work. He said she would be asked questions under oath, subject to the penalty of perjury. And he said that will haunt her long after she is Attorney General. Every word of that statement is legally precise, and it tells us exactly why the Attorney General scrambled to arrange a voluntary briefing the moment the subpoena landed. Here is the difference between what happened in the Judiciary Committee hearing and what happens in a closed-door deposition. In an open hearing, a witness has tools available to her. She can run out the clock by giving long, non-responsive answers. She can pivot to unrelated topics. She can ask rhetorical questions back at members. She can deploy whataboutism. She can perform outrage. She can invoke the Bureau of Prisons as a shield. She can say I was not involved in that at all and move on before anyone can press her. The cameras are rolling, the member's time is limited, and the witness controls the pace. In a closed-door deposition under oath, none of those tools function. There is no clock to run out. There are no cameras to perform for. There is no audience to play to. There is a court reporter. There is a transcript. There is an oath. And there is the penalty of perjury, a federal felony carrying up to 5 years in federal prison, attached to every word she speaks. Under those conditions, the questions Congressman Khanna listed become a very different kind of problem for the Attorney General. Let us examine each of those questions forensically. Question 1. Why were 3 witness interview documents, specifically relating to the woman who accused Donald Trump of rape when she was 13 years old, withheld from the Epstein files release? This is a specific factual question about a specific set of documents. The documents either exist or they do not. If they exist, someone made a decision to withhold them. That decision was made by someone within the Department of Justice. The Attorney General is the head of the Department of Justice. Under oath, she cannot answer this question by saying it is a question for the Bureau of Prisons. The Bureau of Prisons does not control DOJ investigative files. She will have to answer who made the decision, on what legal basis, and whether she was aware of it. If she was aware of it and authorized it, she must explain the legal justification for withholding evidence relevant to a congressional transparency mandate. If she was not aware of it, if a decision of this significance was made inside her department without her knowledge, then she must explain how that is possible and who is actually running the Department of Justice. There is no third option. Question 2. Why have documents been scrubbed? Specifically, why have the identities of rich and powerful men named by survivors in official 302 interview forms been concealed? A 302 form is an FBI document. It is the official record of a witness interview conducted by federal agents. When survivors name individuals in those interviews, those names become part of the official investigative record. The Epstein Files Transparency Act was passed specifically to make that record available. The concealment of those names, the scrubbing, as Congressman Khanna described it, is not a bureaucratic decision. It is a deliberate act. Someone reviewed those documents. Someone decided which names to redact. Someone signed off on those redactions. Under oath, the Attorney General will have to identify who made those decisions and on what authority. This is where the perjury risk becomes acute. Here is what we know from the public record. In the open hearing, Bondi stated she did not know who authorized the Maxwell transfer. She stated she was not involved. She stated it was a question for the Bureau of Prisons. She stated the facility was the same level. That last statement is contradicted by documented prison classification records. It is a specific factual claim about a verifiable fact. It is the kind of statement that, if shown to be knowingly false, meets the legal definition of perjury. Now she is being asked to appear under oath and answer questions about a pattern of decisions, the Maxwell transfer, the file redactions, the withheld interview records, the refusal to meet with survivors, that together suggest not isolated errors of judgment, but a coordinated management of the Epstein case. Under oath. With a court reporter. With the transcript preserved. With the penalty of perjury attached to every answer. Congressman Khanna was precise when he said this will haunt her long after she is Attorney General. He was not speaking rhetorically. He was describing a documented legal reality. Testimony given under oath becomes part of the permanent record. It can be used in future proceedings. It can be compared against prior statements. It can be compared against documentary evidence. And if there are material contradictions between what she says under oath and what the documents show, that is not a political problem. That is a criminal exposure. Now let us examine what her sudden willingness to appear voluntarily actually means. A witness who has refused to answer questions for months does not voluntarily appear the same day a subpoena is issued because she is suddenly comfortable with transparency. She appears because she is attempting to control the conditions of her testimony. A voluntary briefing is not a deposition. It is not under oath. It does not carry the penalty of perjury. It can be shaped, limited, and ended on terms she negotiates in advance. It is, as Congressman Khanna noted, the equivalent of attempting to plea bargain the moment the indictment arrives. But Chairman Comer has a choice. He can accept the voluntary briefing as a substitute for the subpoenaed testimony, or he can accept the briefing for the information it provides and then proceed with the subpoena anyway, because the subpoena demands sworn testimony. A voluntary briefing provides none. The legal standard is not satisfied by a conversation behind closed doors where no oath is administered and no penalty attaches to false statements. Congressman Khanna made his position clear. He wants Comer to pursue the subpoena with the same relentless insistence that Comer applied to previous investigations. He wants the Attorney General under oath, not briefing. Oath. The institutional logic is straightforward. The Epstein Files Transparency Act is a law. Laws carry obligations. When the head of the Department of Justice fails to comply with a law passed by Congress, Congress has the authority and the constitutional duty to compel accountability. The subpoena is that mechanism. It is not extraordinary. It is the standard procedure for compelling testimony from a witness who has demonstrated unwillingness to provide it voluntarily. What is extraordinary is that this subpoena was necessary at all. The Attorney General of the United States, the nation's top law enforcement officer, has had to be compelled by legal force to answer questions about whether her department is complying with a transparency law passed by the legislature she is constitutionally required to serve. The questions are documented. The subpoena is issued. The closed-door session is scheduled. The oath is waiting. The record she creates under those conditions will follow her. We will be here to analyze it. Stay with us.